Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning and welcome to the Fourth Circuit, and please be seated. Judge Richardson and I are pleased to welcome Judge Nachmanoff to join us today, and we look forward to everyone's arguments, so don't disappoint us. And our first case will be Longworth versus Mansuhaki, something like that, et al. And Mr. Brugato, you're first.
Good morning, Your Honors, and may it please the Court. Thomas Brugato for Plaintiff Appellant Justin Longworth. This case is a Bivens action where the plaintiff, Mr. Longworth, alleges that Defendant Beck, a Federal Bureau of Prisons employee, sexually harassed and sexually abused him, constituting excessive force in violation of the Eighth Amendment to the U.S. Constitution. Mr. Longworth further alleges that the remaining defendants, also Federal Bureau of Prisons employees, knew of this abuse but failed to take steps to halt it, and thus were deliberately indifferent to the violation of Mr. Longworth's Eighth Amendment rights. There are two issues presented in this appeal. The first is whether the Federal Tort Claims Act's judgment bar at 28 U.S.C. 2676 requires dismissal of this case, even though the Bivens action was decided before Mr. Longworth's FTCA claim was dismissed. And second, whether on the merits a Bivens claim here is cognizable based on the facts alleged in the amended complaint.
Which we would not reach if the FTCA bar applies.
Correct. We would not reach the merits if the bar applies.
All right.
So turning first to the judgment bar issue, the question here is whether a later filed FTCA action that reaches judgment bars an earlier filed Bivens action that already was the subject of a district court judgment. And I think our argument here is relatively straightforward. Our argument is that the judgment bar should not be interpreted to apply retroactively when the Bivens case goes to judgment first, and Congress would have been more express had it designed the judgment bar to apply retroactively.
Well, the statute seems to be pretty plain. The judgment in an action under the FTCA shall constitute a complete bar to any action by reason of the same subject matter. And it's not time restricted.
But it's also not expressly indicating that it's looking backwards to a prior Bivens judgment. And that would
Why do you say it's looking backwards, right? I mean, it doesn't naturally look backwards at all, right? The question is whether the FTCA judgment at time zero bars the appeal today. That's forward-looking. That's not backwards. I mean, there's a hard question that if you wanted to go back and think about a different case, but here, what it bars is your appeal, right? And your appeal happened after the FTCA judgment. So help me understand. I understand you want to call it backwards looking, but that seems like the wrong way of even thinking about the question, isn't it?
I don't think it's the wrong way of thinking about the question, because the logical implications of the government's argument here is that a prior Bivens judgment, even a favorable one, should not be allowed to stand if the FTCA judgment is entered. So I think the implication is that
might be a different case, might have the same implications, but that might have, in a different context, some retroactive effect if we barred an appeal in a different context. But here, it would not have that effect, right? It has no retroactive effect because they prevail below and your appeal is being stopped, right? So this is not changing anything that happened before. There's nothing retrospective in effect.
I mean, I think the retrospective piece of it would be that it is retrospectively precluding Mr. Longworth from continuing to pursue his appeal of the judgment.
So what's your best case that says that you would prevail at this from any circuit?
So I think our best case would be some dicta from the Supreme Court on this issue in Simmons v. Himmelreich, footnote 5, where the court says that the judgment bar provision applies when a plaintiff first sues the United States and then sues an employee. So, and that's consistent with dicta out of the Ninth Circuit and an unpublished decision from this court, all indicating that the judgment
But
bar
the
should
Supreme Court
apply.
there, I mean, what the Supreme Court says is true, right? But what you want us, it does apply there. What you want us to read is read into that dicta only, that it only applies in that context.
Well, I think what the Supreme Court's doing is describing when it applies, and is being pretty exhaustive in describing it in that fashion.
What about our decision in Unis versus Kane? That seems to be pretty strongly not in your favor.
Yeah, so UNIS certainly addresses a similar issue, which is whether when a
Do you
Bivens...
say it's wrong?
No, we're not claiming that that decision's wrong on this appeal.
All right. What about the Seventh Circuit's opinion in Manning?
Again, Manning addresses a similar but distinct issue of whether contemporaneously filed Bivens claims and FTCA claims in the same suit should be barred if the FTCA judgment comes second. It doesn't address the question of a separate Bivens case.
Well, counsel, what is the significance of that difference? In other words, in Manning, they were filed together, but the jury returned its verdict on the Bivens case first. The judge took the FTCA case under advisement and then later vacated the judgment in favor of the plaintiff on the Bivens case. But what difference does it make that in this case, the only difference is that the actual actions were filed at different times?
I mean, I think the difference is that in this case, there's an actual independent judgment that would have its own claim preclusive effect that should be allowed to stand on its own without being overturned by a subsequent FTCA decision. I think that's the real difference, is that there's an independent judgment as opposed to the happenstance of which claim was decided first in a combined lawsuit.
Why does the independence matter? You seem to, I mean, I think what you're saying there is that whether it's independent matters? Why is that? And to the extent you can you tie it back to the actual statute? Like what about it is suggesting that to you?
Yeah, so again, I mean, in terms of the statutory language, our argument is just that Congress would have been more explicit if it wanted to preclude prior actions. But I think our point is, as sort of a policy and prudential matter, when a judgment is independently entered, it has full legal force and vitality, even if it's appealed. It has claim preclusive effect, and that certainly in that case, Congress would have been more explicit if it wanted an FTCA case to be able to wipe out a prior judgment.
So if you were to prevail, then I would think the continuing legal education advice would be always file your Bivens first.
That would be the strategic decision if we were to prevail, yes.
Because we generally don't go in for too much gaming like that.
So I would say that there are two items that would address that concern, Your Honor. The first would be the statute of limitations for an FTCA case where an individual has 2 years to file a claim with an agency and then 6 months to file litigation after that claim is decided. And then the second, again, as the Supreme Court in that footnote 5 of Simmons indicated, would be claim preclusion. A decision in the Bivens case would, in some instances at least, be claim preclusive of a later FTCA lawsuit. So I think those two items address the possibility of gamesmanship for the most part.
So I sort of thought you were going to make a different argument, and I just want to get your take on it. So the Supreme Court said in a variety of different contexts that this judgment bar sort of derives from or has roots in the common law doctrine of res judicata, right? This comes up in Brownback and Simmons and Will and otherwise. And in that context, the court has then interpreted words like judgment in light of the soil that it comes from, right? That this word judgment means judgment as we think about it in res judicata terms. You've not really argued, or at least I'm not understanding you to argue, that the common law of res judicata suggests that your interpretation is right. You're suggesting, just as you said, sort of a policy prudential argument, not that we should draw some conclusion out of common law and incorporate it into the statute?
Well, so the one part of that I would say slightly differently would be we are making a bit of a common law argument by analogy, which is the point I made earlier, that the first judgment is typically the one that has claim preclusive effect, not the second. So it's very odd to say, well, actually, we're using the second judgment to have claim preclusive effect to wipe out the first one.
So that seems like flatly inconsistent with the common law. The common law seems to say exactly the opposite of that. So like the first restatement of judgments and otherwise suggest that that is not what the common law says. So where would I find the common law that suggests the temporal limitation that you've suggested?
That the first judgment is the one with claim preclusive effect?
Yes.
Yeah, that's restatement first of judgments 43, where two actions are pending between the same parties, which are based on the same action or which involve the same issue. It is the first final judgment rendered in one of the actions, which becomes conclusive in the other action.
And so the premise that so walk me through how that helps you.
So
Because the nature of res judicata is we know that the Bivens action doesn't have preclusive effects on the FTCA claims because there's not mutuality, right?
I'm not so sure that's correct. I mean, the Supreme Court in Simmons again suggested that there would be claim preclusive effects because there's an employer-employee relationship, which is a privity-type relationship.
Okay, except hypothetically for a minute that that's wrong.
Okay.
And so in that scenario, the restatement first would tell us there's no preclusive effect from the Bivens, but then the statute is telling us that it does run in the other direction. So there's only one judgment here that could have preclusive effect, right? That being the FTCA judgment by virtue of the judgment bar, right? So why do we think that there's a first in time and a second in time? There's only one that has preclusive effect here.
Yeah, I mean, I think that Your Honor is correct if we accept the premise that the first judgment is not in privity and there is no preclusive effect.
All right, so then help me to go back to the premise of the question or the premise of your point. Can you tell me where I should look to find the idea that a Bivens action, which refers to the acts of an employee, has preclusive effects on action against the employer?
Yeah, it's footnote 5 of Simmons where the court says the judgment bar provision supplements common law preclusion by closing a narrow gap. The time that the FTCA was passed, common law claim preclusion would have barred a plaintiff from suing the United States after having suing an employee, but not vice versa. And then it cites a few provisions of the restatement of judgments.
Okay, and so your theory is that because it then bars, so now play that out for me just a second, and you can talk about Bivens if you want to. Why does that matter in your process?
Yeah, so it matters because what should have happened would be that the Bivens judgment would be entered, the Bivens judgment would have claim preclusive effect, and that would be relevant to the disposition of the FTCA case, not the opposite, where the FTCA case independently goes to judgment and then wipes out the prior preclusive effect of the Bivens judgment.
And did anybody argue here that the FTC action was, subject to preclusion from the Bivens?
In the FTCA case, I don't believe so, Your Honor.
Okay. But that's the argument, that's the common law argument that you're making. You're not making an independent common law argument from that.
Correct. Are there any further questions?
Well, do you want to say anything about your second issue? You've got a little time.
Sure. So I think on the second issue, the main thing I would emphasize here is the court's decision in Fields, which came down after briefing in this case was concluded, which I think is really a quite similar case to this one involving an Eighth Amendment excessive force case, where the court goes through and rejects a number of the very same arguments that the defendant appellees raise here about the PLRA being an adequate alternative remedy, about the FTCA being an adequate alternative remedy, about other special factors. And I think should the court reach the merits is a very instructive case that is pretty aligned with our case here. So that's what I would suggest on the Bivens piece, is that a lot of the briefing has been effectively superseded by that decision.
Okay. Anything else? Thank you. Okay. All right, thank you very much. You've got some rebuttal time. Mr. Silberman, we'll hear from you first.
Thank you, Your Honor. I represent my name is Jonathan Silverman. I represent defendants Garantini, Mushahani, Hout, and Burrell. The judgment bar, by its terms, is a complete bar to any action by the claimant by reason of the same subject matter. An action is defined in Black's Law Dictionary as a civil or criminal judicial proceeding. And as the Supreme Court has instructed, this is interpreted according to its plain terms, and as the Seventh Circuit noted in Manning, this has no temporal element. In this case, Mr. Longsworth brought a claim under the FDCA about the same allegations against these same parties. That claim has a judgment in it. That judgment acts as a bar. It stops any further proceedings as to the Bivens claims. And it does not matter whether Mr. Longworth filed his Bivens claim before his FDA claim or he filed his FDCA claim a second, a minute, a year, 5 years later.
So is this, in your view, is this case resolved by the plain language of the statute, or is it more nuanced than that?
No, Your Honor. It is the plain language of the statute. It is interpreted according to the plain language, and the plain language says that it is a complete bar to any action. As long as there are steps to take, there is no more to be done. As long as there are steps to take in a different action, the judgment in the FDCA is a cold stop as to the Bivens claim. On that grounds alone, the district court should be affirmed. In citing otherwise, they cite to Simmons, but Simmons itself notes the oddity in giving emphasis to which claim gets filed first, which actions would get filed first. And Judge Agee, as you pointed out, if the CLEs start teaching that a Bivens claim just has to be filed before the FTC action by a second or however long, the FTCA judgment bar would be a nullity that could be easily circumscribed by a plaintiff. And in other contexts, Judge Niemeyer and Touchette, and looking at the federal rules, we look to try and get all claims from the same action, from the same transaction occurrence in one legal proceeding. That is generally what the federal rules encourage. To hold otherwise, to split the claims and reward claim splitting, would be to go against the general thrust of the federal rules and what makes the most sense under the federal rules. Again, for that reason alone, the district court judgment should be affirmed. If this court were to reach the Bivens claim, there are a number of reasons. First, this is a new context. There's never been a sexual assault claim or any different sexual assault claim recognized by the Supreme Court, and therefore this is a new context. As to the remedies, there's a variety of remedies available. The alternative remedy program, as they use in this case, the FDCA is available. There's now some language in the compassionate release U.S. sentencing guidelines that can do it. There are other deterrents on the books. Criminal sanctions come to mind. As to my clients who are bystanders in this case, the Prison Rape Elimination Act, the regulations enacted under that require them to report at suspicion, not knowledge. They actually have to report at a lower bar than the Constitution would require, and therefore, and they face termination if they do not do so. That is a strong reason to report, and another reason why Congress has acted in this space. There's one more thing we'd like to touch on is the Federal Prison Oversight Act. The Federal Prison Oversight Act was passed, I believe it was July of this summer. The Federal Prison Oversight Act is creating an ongoing dialogue between the executive and legislative branch in this area. There'll be reports going to Congress. Congress is going to get more information and can enact craft solutions as it sees fit. That is another reason to pause. Your Honor, if
Do you have anything else?
there are any questions?
Unless there's something else you want to tell us, I think we understand your argument, and we'll be glad to hear from co-counsel.
Thank you.
Mr. Ballinger, you have an introduction to make?
I do, Your Honor. Thank you. May it please the Court. My name is Scott Ballinger. I'm the Director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce Mr. Frederick Kieser, who will be presenting argument for Ms. Beck.
All right, thank you. Mr. Kieser, come on up.
Thank you, Your Honors. If I may, I'd first like to address the retroactivity point that Mr. Longworth's counsel raised. Just like Judge Richardson said, we don't believe that the presumption against retroactivity would have any bearing on this case at all, since he's asking for his judgment to be vacated and remanded for trial, all of which would occur in the future. So the judgment bar's application would be wholly prospective. Moreover,
Do you think that matters? So, his response to my position seemed to suggest, and he can take a different one on rebuttal if he likes, but seemed to suggest, okay, maybe that's right, but that would also mean, if we interpret it that way, that it does apply retroactively in the flip case. So imagine that he had prevailed on the Bivens action and gotten monetary judgment on that, and you had brought the appeal. Do you think that that would be a different case, or would the judgment bar not apply there too? And if so, then doesn't his argument about retroactivity have some import?
first, I think that the judgment bar wouldn't apply there because by its terms, the judgment bar only applies in one direction in that it bars actions against government employees. So a government employee's appeal itself wouldn't be an action against a government employee. So the judgment bar wouldn't be subject to being triggered there.
What? Okay, help me understand that a little bit. So the story that I've suggested would be he got a money judgment against the employee.
Yes.
And you have filed an appeal here, raising whatever claims you want to raise. But in the interim, there's an FTCA judgment, right? And so in that case, I assume you would argue that that FTCA judgment is a complete bar to his action, that is, to his recovery of any money. And so the Bivens judgment would have to be vacated, right, because there's a complete bar. And
Yep.
that would have the sort of colloquial effect of having a retroactive impact, right? Because it would require vacating a judgment that had been entered.
Yes, Your Honor, sorry, I misunderstood. I thought you were
I
getting...
wasn't clear. That's not on you.
I thought you were getting at the point that it would bar our appeal from the Bivens judgment, which we don't think it could because it only applies to actions against government employees.
Totally fair, right? It would not bar your appeal.
Yes.
It would actually be another arrow in your quiver, right? You would come back and say, our appeal effectively ought to prevail, and you ought to vacate that judgment because there's a complete bar to any action.
Yes, Your Honor.
And that does have a retroactive feel to it, right? I mean, at least in the colloquial sense.
Yes.
Right.
And we agree, but we just believe that Landgraf and its progeny have no bearing on the judgment bar's application in that Manning-like circumstance because the judgment bar was enacted over 70 years ago and Landgraf itself concerns statutes attaching new legal consequences to conduct that occurred before the statute's enactment.
Does it matter to you that when this statute was passed, neither Bivens nor the Westfall Act nor any of the sort of things that have led us here existed?
I do not think that it matters because of the strength of the language. Congress used any action. It bars any action against a government employee by reason of the same subject matter, so I think it applies equally to Bivens as it did before the enactment of the Westfall Act where it would apply to a state tort law claim against a government employee. And then one other point I wanted to raise on your concerns about its retroactive application. I don't think that there's anything retroactive in the time-honored sense of a court of appeals deciding an appeal according to the law as it exists on appeal. And so again, I just do not think that there would be any sort of retroactivity kind of problem in that circumstance. And then Judge Nachmanoff, I wanted to discuss a point that you raised in counsel's opening about that we don't think that there's any reason to treat an action that was filed separately any differently than a contemporaneous claim. And indeed, the great weight of the case law has suggested that the opposite, that the harder question is whether it applies to claims within an action because one of the judgment bar's purposes is to bar duplicative litigation. So we believe that the fact that Mr. Longworth filed two separate actions makes his claim worse, not better here. Finally, I want to...
Go ahead.
I'm sorry, I was just going to say, how do you address really the policy argument more than the legal argument about the administrability of this? What if there's a judgment at some time, these things all overlapped, but what if there's a judgment at a much earlier time and then the FTCA claim is resolved at a much later time? How do you undo that? How would the court even address that if the plaintiff, for example, had prevailed and won a money judgment that had been paid out, for example?
So I think it would depend on the circumstances of when that first Bivens judgment was entered, because if it's no longer subject to appeal and it's a truly final judgment, then I don't think the judgment bar applies there because it bars actions, not judgments. But so long as the Bivens judgment is on appeal and it's still an action against a government employee, a Bivens appeal itself is an action by its terms and would prohibit that appeal.
Can I ask a slightly different question to go back to the hypothetical? Obviously, it's not the one we've got that Judge Nachmanoff raised, where they're both filed, the Bivens and the FTCA action are both filed in the same action, so they're in the same complaint. Can you help me understand how, given the language here, if we had that, which we don't, the bar would apply? Because in a sense, it says there's a complete bar to any action, but there we have two claims in one action. But the FTCA's language goes on to talk about, right, bars any action by the claimant by reason of the same subject matter against the employee of the government whose act or omission gave rise to the claim. How would you interpret the statute in that context where they're both filed in the same action?
Yes, I think you're getting at the point that maybe you're talking about what Justice Sotomayor raised in her concurrence in Brownback about the kind of consistent argument that it doesn't apply to claims, but it would apply to separate actions. And I know that the Manning Court and a lot of different courts have talked about it applying to contemporaneous claims because an action's definition in and of itself includes claims, and so it's kind of like because it covers the larger, it would have to cover the smaller. And I think that that is the unanimous position and the one that this court took in Unis itself, where it barred the appeal of two dismissed Bivens claims because of a subsequent FTCA, or kind of subsequent summary judgment being granted on the FTCA claim.
And were they in Unis, were they all in the same complaint, the same broad action?
Yes. Finally, I wanted to discuss their independence argument about the judgments. I think it misses the point here because they're asking for the judgment to be vacated itself. And so the whole idea that there would be a judgment having claim preclusive effect, I don't think would apply since the judgment would be vacated, or he's asking the judgment to be vacated. And also, Simmons itself, the holding is that the plain text of the judgment, or the plain text of the FTCA controls. And so I think even in the hypothetical you were talking about, where if it were to restate or incorporate claim preclusion principles, we know from Simmons' core holding that it's the plain text of the FTCA that controls. And it only went on to address that extra argument by pointing out that a reading that ignored the text would diverge from the common law. But we know that the plain text would control in either situation.
All right, got anything else for us?
I think that covers it. Thank you, Your Honors.
All right, thank you very much. Mr. Regato, you've got some rebuttal time.
So just a couple of points to raise on rebuttal, Your Honors. The first is there were concerns raised regarding claim splitting by opposing counsel. There's a solution to that. It's the doctrine that prohibits claim splitting and allows a district court to dismiss a case if claims have been split. So to address that, there's no need to invoke the FTCA's judgment bar. The second item I'd like to address is a comment made by Judge Richardson about whether it matters that Bivens was subsequently decided long after the FTCA judgment bar was enacted. And I think the answer to that question is yes. And I would point to this court's decision in Fields and the Supreme Court's decision in Carlson, which talk about amendments to the FTCA in 1974 to allow both a Bivens claim and an FTCA claim to proceed in complementary fashion. So, an argument can be made that Congress...
Do you think that implicitly overruled the judgment bar language?
I think
Is that the argument you're making?
I don't know that we're going that far. I think we would argue that the judgment bar, it supports our interpretation of the judgment bar as not applying retroactively, and, Congress not wanting to...
Why would that help you? I mean, the judgment bar is what it is, but why would we think like a separate amendment in a different context, like whatever it was, 30 years later, sheds light on what the meaning of a statute enacted in 1946 is. I know some people think that like the law just evolves as it goes, but like we do tend to think about what the statute meant when it was passed, right? And it may have unusual applications, right? That's an issue that comes up regularly, but we don't typically think about, you know, sort of the language of a different statutory provision 30 years later as changing or influencing the meaning of a statute that has been on the books for 30 years, do we?
I mean, typically not, and I think that's a fair point. And I guess, you know, one would have to make an argument that Congress did implicitly allow for a Bivens claim and an FTCA claim to proceed simultaneously, even though it didn't expressly amend the judgment bar's
Well,
text.
it certainly could allow them to proceed simultaneously, but that doesn't preclude there being a judgment bar for when one is issued or not, right? I mean, those two ideas are not in conflict, I guess is my point.
They're in tension, but they're not in direct conflict. Any further questions on the judgment bar issue, Your Honors?
Got anything else?
Yep.
No, we
Thank you.
appreciate it very much. We will come down and greet counsel, and then we'll move on to our next case. Our next case is United States versus Elfenbein. Mr. Mettinger.
Good morning, Your Honors, and may it please the Court. My name is Jason Mettinger, and I'm here on behalf of the United States. But in many respects, Your Honors, I'm also here on behalf of the jury that heard this case. Your Honors, jury verdicts demand deference, and we respectfully submit that the jury verdicts here did not receive the deference that they were due. Your Honors, this was a healthcare fraud case. The jury in this case heard 2 weeks' worth of testimony. They heard more than 200 exhibits. They heard and saw from the defendant himself. And after all of that, the jury properly and reasonably and swiftly returned verdicts on all counts. We respectfully submit that the district court was wrong to substitute its judgment for the jury's. District court was wrong in the standards that it applied, and the district court was wrong in granting Rule 29 relief and conditionally granting Rule 33 relief. As such, we respectfully ask this court to reverse and to reinstate the jury's verdicts. Your Honors, I'd like to start with Rule 29, and I'd like to start specifically with the standards that we have to apply here. Because
I think I'm confident my colleagues understand the standards as well. Can you turn to JA 102? This is the chart, right? You can probably remember it from memory, and the words don't really matter. But do you agree that the evidence only permits the conclusion that satisfying 2 of the 3 columns is a way, not the only way, but is a way to justify a level 3, 4, or 5 code?
So, yes, I think that is some of the testimony that was involved here.
I know, but what I'm asking, is there debate about that, right? That if, acknowledging if, one were to establish that 2 of the 3 columns were met, that would suffice to establish that the Code 4, I'm just gonna call it Code 4, I know it's got a lot of other numbers before it, but that the Code 4 billing was proper.
Right, so there was testimony on that, and both the government expert and the defense expert, I think, agree generally on the parameters of it.
Okay.
I think where we disagree, frankly, is the facts. And we
Okay.
have wildly disparate views of them, and our view is the jury resolved those discrepancies in our favor. And the district court applied a different standard, and that's where we think there's error.
Totally get you. So, in the first column, where, can you point me to where your expert, if so, talked about whether these individuals, you know, under the number and complexity of problems addressed that they encounter, did your expert address whether this was an undiagnosed problem with uncertain prognosis?
So
Right,
what,
that's that sort of particular, I mean, I get there are lots of different bubbles here, but that one sort of strikes me as particularly interesting. Did your expert address that issue, and if so, can you point me to where?
So where our expert addressed that was when he was talking about the codes and he walked through the CPT manual. He didn't provide enormous amounts of gloss on it, but he did walk through what it meant. And so he read into the record the idea that an undiagnosed new problem with an uncertain diagnosis has to represent a condition that's likely to result in a high risk of morbidity without treatment. And that's right from the CPT code, and if in a JA site of it is 99, also JA 4663. So it's an enormous record. So, Your Honor, in our view, you know, this doesn't meet that standard on any of those. It's not undiagnosed.
Okay, so.
But counsel,
Yeah,
I'm sorry, I
Yeah, please.
didn't mean to interrupt. That expert wasn't a doctor, right? So there is no testimony from the expert about what it means to be an undiagnosed new problem, right? He was talking about the application of the CPT, but he couldn't talk about the underlying medical issue, could he?
No, he could, Your Honor. So he was an expert and certified in coding. And so really that's what we're talking about. We're talking about one of our theories was upcoding. Obviously another theory was this false documents, which we can get to. There was a number of falsities in this case. The CPT manual was only one of them, but I'm happy to talk about it. So he certainly could talk about whether he's a certified coder. We had other certified coders that says these weren't level 4s. Sinagra was a certified coder. There's a couple others. So we certainly
But counsel, and maybe I've misinterpreted my colleague's question, one of the issues underlying this is what was COVID? What were people who needed these tests really suffering from? And is it more like the example of the assessment of a lump in the breast, or is it more like coming in with a cold? And the doctor then, or the healthcare professional, would have to make an assessment according to that chart.
Right, so I have 2 responses to that, Your Honor. Number one, we're talking about experts. I do want to make the point that we don't believe that an expert here was required. That's one of the errors that we think the district court made in requiring expert testimony. Expert testimony is never required to prove an element in a criminal case. That's that Sanjar
The district court
case.
didn't think too much of your expert anyway.
He did not. And that drove a lot of, I think, the decision here. The district judge did not think well of our expert, and you know, we got the result that we did.
So what I think to Judge Nachmanoff's question, maybe if I can, hopefully friendly, sort of addition to it or revision. So when I look at the evidence that you put on in your case in chief, where do I find sort of evidence that meets the standard, I think that you correctly point to on J99 that your expert talked about, this high risk of morbidity? Like, where do I find evidence that, you know, young, healthy people did not face a quote, unquote, high risk of morbidity from COVID? Like, how could a jury reach that conclusion based on the evidence in your case in chief?
Well, so I was going to talk to you about some of the, 2 points, actually. First and foremost, they can find
You can
it
talk about
in the
their
records.
evidence too.
I know, I want to
but
talk about
let's
their
start,
expert in a
I know,
second.
and I assure you, we're gonna get to that, but I wanted to start with what evidence you put on. You are correct that when we have analyzed this, they get the burden of the evidence that they put on too. And so that might make a difference here. I asked the question precisely for a reason.
Understood, Your Honor.
So what is the evidence in your case in chief that would suggest to us that there was not a high risk of morbidity, at least for, you know, the general population, as opposed to someone who is old or has diabetes or some other condition that exacerbated the risk they faced?
Right, so if you look at the record that indicates the medical records for the charged counts. So that's, you know, JA 3671, 3685, 3755.
And you're talking here about the, I believe, 5 specific individuals?
Correct.
Okay.
And so, you know, you look at the treatment. The treatment that was proposed was, you know, go home, rest, hydrate, use some over-the-counter medications. Combine that with the CPT manual, which says that a level 2, sort of a straightforward, basic, you know, low-level medical decision-making is going to resolve by those kinds of treatments. And put those two together, and the jury is reasonably able to see that the kind of problem that was being presented here, this COVID problem, is a minimal problem, a level 2 problem, nowhere near the level 4 problem that requires moderately complex medical decision-making. Now, I would like to, you know, because we talked about the defense expert here, I would like to transition to them too, because they said—
Can you, you don't have to know this, but when you say level 2, the CPT manual tells us that level 2 resolves by sort of rest and over-the-counter. I know that their expert testified to this fact, but do you happen to know where that is in the CPT manual?
So it is in here in the definition of, the CPT manual defines each and every one of these.
Okay, that's where I'd find, I don't need you to look that
That's
for
where
me.
you would find it. So
Okay,
it's
that's fine.
It's
And then can you talk, so that's
4663.
4663?
Yeah, and that talks about a self-limited or minor problem is one that runs a definite and prescribed course, is transient in nature, and is not likely to permanently alter health status.
Yep,
And
but that's
there was-
different
and
than
there
it will
was-
resolve with rest and over-the-counter, right?
Right, but you know, this is not a complex medical decision-making operation. And I know we're kind of getting down into the weeds of the CPT manual.
Yeah, no, I'm definitely asking to get in the weeds.
You know, we
Stay in the
respectfully
weeds for just a minute for me, and then you can come back up and talk about 30,000 feet as much as you think it's gonna be helpful for you. So we talked a little bit about your case in chief, and you pointed to a few things with respect to this risk of mortality or morbidity for healthy individuals. You were gonna talk about the defendant's expert and how he helped you on that. Can you tell me what you think I should look at for that point?
So thank you, Your Honor. So that goes back to the points we were discussing where the defense expert, Mr. Misko, says that a level 2 is something that's going to resolve with over-the-counter drugs and instructions like rest, gargling, having a sore throat, something like that. That's JA 1870 and 1901 to 1902. So he's saying that's a level 2 problem, and that is what these patients are being told in their medical records. Just rest, use some Tylenol. And the jury can marry those two up and say, we see an expert saying a level 2 is something that you just got to have Tylenol for. And then you look at the medical records, which the prescription is, you got COVID, quarantine, rest, take some Tylenol. And so they can reasonably infer that this was a level 2 problem, not a level 4.
Well,
The other thing that I want to
Let me pose
mention—
a hypothetical question, I hope is quasi-related. If we were to assume, just for purposes of argument, that we concluded, based on the record and the district court's opinion, that as a matter of law, the defendant could not be convicted only on the basis of the interpretation of the CPT manual. Is there other evidence of fraud in the record that is sufficient to support the verdict?
Yes. So
You want to tell us about that a little bit?
So abundantly. And, you know, the first place we get to, Your Honors, is this false medical records. Both experts agree that if false medical records underlie a reimbursement request, that request is false. And so all we have to prove, and especially at this stage, all we have to believe, is that the jury credited some of the witnesses to say that they had false medical records. And patient AH said that her medical records didn't match her experience at all. She was adamant about that. All of them did. Patient WR, DM, JJ. So we also have additional evidence of knowledge of falsity. There's a couple emails in here where Dr. Elfenbein is told people aren't getting exams, and yet the medical records are saying that they're done. There's JA 4456. No one is listening to their lungs or doing any type of physical exam. Dr. Elfenbein himself said, JA 4436, we are not doing an exam. And yet all the records showed there was a physical exam. And so based on that alone, we get to falsity. But as we said, there's additional other indications of falsity, and this gets back into the CPT manual a bit, but again, it doesn't go into the weeds of it. We have JA 4487, Dr. Elfenbein admitting, we're not here to solve complex problems, we're just here to test them. He also said, what we're doing is simple and straightforward. That marries up with level 1 or level 2. You also have consistent statements from a number of providers saying, these are not level 4s. You have Kathy Raymond who's saying that. You have Deborah Needle saying that. You have Crystal Raymond. She did all of these and coded some of them level 2, level 3. That's what she thought was appropriate. Dr. Elfenbein overrode her and said, no, I'm countermanding you and I'm making all of these level 4s across the board, regardless of what's going on. You had the audits, which said it was wrong. The CMS guidance, there's also some circumstantial evidence. You know, the jury heard all this. So again, you have to picture the evidence as it's coming in. They're hearing testimony about a lived experience, frankly, that we all had. We all sat in those cars, waited in line, got our noses swabbed. Everybody knew what this was. The testimony came in and established what it was, and they asked themselves, is this moderately complex medical decision-making? And they reasonably concluded, no, not by a country mile. Because that just wasn't what was going on here. This was an assembly line. They were just moving people through the queue. And so, again, we have to take all of the evidence as it came in. We have to construe every inference in favor of the government. And if you do that, that supports the jury verdicts. I would like just to talk very briefly about the district judge's opinion, because I think in some instances he countermanded his own jury instructions. And that's another sort of problem that we have here. So jury instructions say, jury, I'm defining falsity. It's something that's false or fraudulent, meant to conceal. It tracks the standard jury instruction language. That's a JA 2455. And then later in the Rule 29, essentially there's a whole new element that we have to prove. You know, the judge put us in a spot where the jury instruction said X, the Rule 29 motion says Y. Interestingly, he also said, jury, you
What do you claim the new element was?
Well, you know, if you look at what the district court said we had to prove, it wasn't just falsity. Essentially what he said was, see if I have the exact quote here. I don't have it right here, but essentially he was saying the government has to prove that Dr. Elfenbein's subjective understanding of the CPT manual was not reasonable. In other words, you know, the jury instructions just say we have to prove falsity. And this gets into that Gennady case that we were citing, that, you know, we're not here to prove CPT manual vel non. What we're here to prove is healthcare fraud. And this is a larger scheme to defraud, and it goes into much more than just checking boxes on a CPT manual. The other thing I'll say just very briefly before I have to cede the rest of my time is that the district judge said, jury, you can use your common sense. That was the instruction. And then when you get to the Rule 29 opinion, it says the jury can't use their common sense here. And so we see some tension and some dissonance and reversal, frankly, from the jury instructions to the Rule 29. Your Honor, I see my time has ended.
That's correct. This is a complicated case, and I wanted to ask you one more question. If we were to assume that we agreed with you and reinstated the judgment of conviction, what's wrong with the district court's grant of the due trial? Because we have two very different standards.
So that's absolutely correct, Your Honor. There's 2 points I would say on that. Number one, the real fulcrum, we have to ask ourselves, well, what's new, what's different, right? So the district judge didn't grant the mid-trial Rule 29 motion. So what was different that they put in the defense case? The real,
I want you to come back to this, but you do agree, we don't get to review that. Even if we thought the district judge got that absolutely and completely wrong, it makes no difference.
right, we
Right,
have to now,
because, so to sort of rely on that's a little odd, because it was unreviewable at the time, it's unreviewable by us now. And so if the district court was totally wrong then, but got it right later, like, that makes no difference. So I don't know why that, like, temporal line is one that you turn to.
well, it frames it only because I want to logically think about what's different. And so the one thing that was different was they had an expert that testified, so Mr. Misko testified. And to get to your point, Judge Agee, about why that was wrong, the district judge shouldn't have relied upon that expert. Because if you look at what that expert said, he did a cold record review. He just said, these are the medical records, I'm looking at them, I think they meet the standard that the defense suggests. But none of those medical records were accurate. So, it's garbage in, garbage out. If he's relying on fake medical records, his opinion is worthless. And that's why we think the district judge was wrong to rely upon those. The second error that the district judge made in the Rule 33 context, if you look at what this court said in Rafikian, it said that, we're going to reserve Rule 33 for something exceptional. In other words, we're going to reserve it not just for when the district judge thinks the jury got it wrong, which respectfully, I think that's what we have here. We're going to reserve it for something more. And I would cite the Fifth Circuit case that we cited, U.S. versus Crittenden. It kind of discusses this.
Can I ask whether, like, one of those unusual circumstances would be this hypothetical situation? A situation in which one were to believe that the district court absolutely got the mid-trial Rule 29 wrong, but the defense put on enough evidence to convict, unintentionally so perhaps, but the defense put on the evidence that led to the conviction, because the government failed in its case in chief, but the defense, in an effort to defend its case, put on enough evidence from which a jury could convict. Would that be one of those sort of unusual cases, if that hypothetical existed? Would that meet this sort of like little bit of an oddity, right, where the government failed to meet its burden, the district court improperly denied a mid-trial Rule 29, and then the defense put on enough evidence to convict their client?
Yeah, so a very interesting hypothetical, Your Honor, but I actually don't think so, and here's why. Like, that seems...
You think that would not satisfy the Rule 30? Help me understand why that is.
So, I think that claim, I would see that more of like an ineffective assistance of counsel kind of situation, where we're going to review the strategic decision-making of the defense. Why did you put on this case that basically convicted your guy?
It's not ineffective assistance of counsel, right? They made the Rule 29 argument. The district court got that wrong. They now are between a rock and a hard place. They either sort of try to preserve that argument for appeal by putting on no case, or they, join issue and put on the best case they can, and try to convince the jury, right? I mean, that's a tough strategic call, but that's not an ineffective assistance of counsel kind of call. That's just like a tough call that the district court forced them to make.
So it might be.
In my hypothetical, of course.
I guess, Your Honor, what I would say is, stepping back, the first principle we have to abide by is juries are supreme. And, in my view, when we go down the road of
Subject to
granting-
Rule 29 and Rule 33. They're
For
not
sure.
supreme.
For sure.
Right? Supreme suggests that they're not answerable to anything, right? They are
Understood.
quite answerable to Rule 29 and Rule 33.
Understood. But again, if we're talking about using them sparingly, if we're talking about using them in exceptional cases, what I would submit to you, Your Honor, is the Crittenden case, which is an en banc case of the Fifth Circuit, talks about some of the things that other courts have found. Number one that they talked about was assume the government's case had rose and fell on one cooperator. And it was, your proverbial jailhouse snitch. That's all we got. A jailhouse snitch said the guy confessed, and we put that guy in the stand and convict. That is a thin reed to prosecute someone on. And that is a kind of situation that it's exceptional, it's extreme, it's nowhere close. Relatedly, they talked about decisions that were made in passion.
Great.
Sorry,
I think you've answered it.
So I think there's exceptional circumstances, and we're not here. I'll reserve the rest of my time for rebuttal.
All right, thank you very much.
Thank you.
Bernstein.
Good morning, Your Honors. Greg Bernstein and my partner Martin Himmelis on behalf of Dr. Elfenbein. May it please the court. I'd like to begin by saying that one fundamental flaw in the government's argument here today is the statement that everybody knew what this was about. And that could not have been farther from the truth. Let's not forget, we were in the middle of a public health emergency. Everything was shut down. People couldn't go to work. People couldn't go to school. People couldn't travel. People were dying from a disease that no one really had a grasp on or understood. So to suggest that this is just some, common cold, at least as perceived at the time.
So is this argument an argument about his knowledge of the falsity? I sort of understood your argument to focus not on his knowledge, in the brief at least, was a question of whether the coding was in fact false. But you open by sort of suggesting that what your real argument here is the doctor's knowledge, and that he perhaps had a good faith, if mistaken, belief that the coding was accurate.
No, absolutely not, Your Honor. That is our argument. Our argument was clear and consistent.
But whether there was, like, what was going on at the time might well go to his knowledge, but does not dictate whether it was false or not.
Absolutely, Your Honor, but I only bring it up because it was in response to the government's position about our expert, Mr. Misko's testimony and why it was something that was straightforward. That's all. Judge Bredar, more importantly, his opinion is clear that the issue here is the absence of falsity. Falsity is what is the heart of this case.
Well, it seemed like he tied that almost exclusively to the CPT code testimony.
Your Honor, as he should, because that is what the government charged. The government charged a scheme to defraud through the submission of a false statement. The false statement was the submission of a claim for reimbursement at level 4. Judge Richardson, we call them levels, not codes.
Sorry.
Yeah, it's very technical. And Judge Richardson.
So in response to his question, if hypothetically, this is actually hypothetical, I believe that these records were indeed like materially false. But the code was, or the level was correct. So it's a level 4, but the records were false. They made claims of things that happened that didn't happen. Whatever, they're just false. Is your argument that would not support a conviction? And if so, why not?
Well, that absolutely is our argument, Your Honor. And the reason why we make that argument is because that's what the government charged. The government charged the submission of a false claim. And our expert, the only expert, by the way, who addressed these issues, Mr. Misko, testified that...
And so, wait, your position is that if I submit falsified records on behalf of a claim, that is not a false claim?
It could be a false claim to the extent that it reflects services that were not provided.
Like an exam, right? So if it says, we gave an exam to this person, and in fact, they gave no exam whatsoever.
Yes, but, and this is important, CMS, the Center for Medicare Services, put out an interim final rule in 2021.
That's
that
fighting
said
hypothetical.
History and exam does not apply.
That's fighting the hypothetical, though, right? So that's just saying, oh, but that wasn't false in some way, right? But the point is, that's still a false claim. I guess I don't actually understand that argument. Maybe just explain it a little bit.
No, and you're right, Your Honor. I apologize. I am fighting the hypothetical. But my point here is that if you have a scenario in which the claim, the record, contains information that goes to the heart of the falsity of the claim that's being submitted, like for example, if you submit a claim on a level 4, but a provider never saw the patient, and it was only a medical assistant, then that would be a false medical record, if the medical record said that. But we don't have that.
Your argument is it can well be a false claim if the record is false, but there's a separate, like, materiality requirement? Is that
No,
what you're
no, no.
suggesting? That in order, you know, if it said, for example, that this person was seen by a provider and they were not, that would be material in some way?
No, it's not a
I mean, this
materi-
seems like a new idea.
No, it's not a new argument, Your Honor, and it's not a materiality argument. Let's take a step back, okay? You asked the initial question, trying to hone in on what exactly are we talking about, right? And under the manual, there are 3 elements that will determine whether or not this is a level 4. Any 2 of those 3 will get you to level 4. The first is the medical decision-making. The second is the tests that are performed. And the third is the morbidity. No one disputes that the morbidity prong didn't apply, so we're left with the
Tell
number.
me why that is for a minute. Why does, I understand Dr. Elfenbein and your expert, is it Misko?
Misko.
Testified that that the morbidity was low?
Well, I'm just reading from the chart. And for moderate morbidity, examples would be prescription drug management, decision regarding minor surgery, decision regarding elective major surgery.
But
So that
you
doesn't-
agree that the risk of morbidity, which is the column 3, was low or minimal?
Yeah, and everyone agrees to that. So where we're left, Your Honor, where we're left is with the number of tests that are reviewed and the medical decision-making. And the number of tests is not in dispute either. There were 2 tests. There was a rapid test when the patient arrived. There was a later PCR test, and the rapid test was reviewed. And so there's no dispute about that. And the government acknowledges this. So the only issue is the first column, is the medical decision-making. And the only issue there is whether it's an undiagnosed new problem with an uncertain prognosis. Not a single witness testified what that term meant, except for Mr. Misko. Their own expert gets on the stand.
Okay, but help me understand this, right? So you just told me that the risk of morbidity is low. And in order to be an undiagnosed problem with uncertain prognosis, right, JA99 and both experts tell us that there has to be a, quote, high risk of morbidity. Those 2 can't possibly be true at the same time, can they?
They can't, Your Honor. But
And help me understand why that is.
It's because it's determined by the time in which you see the patient. You don't do an after-effect analysis.
But column 3 is determined at the time you see the patient too, right?
That is correct.
Okay.
And that's why
Column
and
3.
those tests were performed in red. They did a rapid test and it was reviewed.
No, column 3.
Oh, column 3, I'm sorry.
Column 3,
Yes.
right, which is the risk of morbidity.
Yes,
You just told me the risk of morbidity was low
yes,
in column 3.
yes. At least as defined in the chart, Your Honor.
And then in column 1, in order to qualify as an uncertain prognosis, JA99 tells us it has to be likely to result in a high risk of morbidity. You just told me that this is not a high risk of morbidity. Help me understand how I can say that column 3 is a low risk of morbidity, but column 1 is a high risk of morbidity.
I'm trying to explain that, Your Honor. Obviously, I'm not doing a good job, and I apologize. You have to view this at the time of the encounter. And so you don't, when you first see the patient, you don't know what the result of the test is going to be. You don't know what the result of the PCR is going to be, which is the second test. And a lot of the rapid tests, for example, came up with false negatives, false positives. So it's, as Mr. Misko testified, you're looking at it when the patient presents him or herself. Sure. You could, after the fact, use the third column to try to justify a level 4, but that just wasn't done here because the first 2 so clearly fit. But the point is, it's not like you go back later and review this and say, okay, well, now what really happened here? Like, I'm sending the person home, to just rest, for example. But also saying, call your doctor. And what happens if the PCR test comes back positive? So I think, Your Honor, the focus should be on the two elements that were relied on here.
So how about, help me with this? And
Because
then
remember,
I'll
Your
let
Honor,
my colleagues
because
go.
remember, only 2 are required for the level 4.
I very much understand. Tell me, what is the evidence that I look to determine that the differential diagnosis that represents a condition likely to result in a high risk of morbidity. Where would I find that
That would be
in the record?
That would be in the testimony of Mr. Misko.
Right, and what Mr. Misko said was that this is a pandemic and this was bad, right? And that's what Dr. Elfenbein said too, but like that's not actually evidence, right? So Mr. Misko said it would be absurd to think that this was a minimal risk. But like that's not evidence, right? That's like a bald conclusion that doesn't help me.
Well,
Right, what I'm asking is there anything that is in the record that suggests to me that for these 5 individuals who appeared to be otherwise young and healthy, that the risk of COVID, that they might have COVID when they showed up, presented a likely to result in a high risk of morbidity?
right. So I would say 2 things, Your Honor. First of all, I would disagree about what Misko's opinion on that. I think it's more than just kind of a tautological statement. I think that he's an expert and he's drawing a conclusion. The second thing I would say, Your Honor, and this is important, at least from our perspective, it's not our burden to prove that it's a level 4. It's the government's burden to prove that it's not. And they introduced no competent evidence, none, to show that it was not a level 4.
Well,
Yeah, go ahead.
so,
I'm
let's
sorry,
say,
Judge.
I don't want to stop, but I'm going to stop.
let's say that the jury hears this and they know that a lot of people would come to these things during COVID because they wanted to go somewhere, they had to have a test. These people, or as Judge Richardson indicated, otherwise seem to be okay. And yet they're being billed at the highest level. They couldn't use their common sense to say, this just doesn't make sense.
No, Your Honor. Respectfully, I don't. First of all, I would say that there really is no evidence other than maybe a few anecdotal statements about people coming because they wanted to go back to work, for example. There's no analysis of that. There's no direct evidence of the number of people that did that or whatever. But more importantly, and this is what Judge Bredar focused on, there are cases, and this is one, respectfully, where the regulations that apply, the rules that determine the falsity or the truthfulness of the claim that is being made are not something that an average jury would understand. These are very complicated terms. Even the government's own...
You understand that the jury was given the question of whether this is a high risk of morbidity, right? And the CPT code tells us directly that you would apply the common language usage meanings of such terms as high, medium, low, or minimal risk, right? Juries are able to do that. I mean, that's the common language usage. The CPT code is telling us this ain't complicated. Once you get to this question, is there a likelihood of a high risk of morbidity, we apply the common language usage meanings. That's exactly what juries do all the time.
Yes, sir, but the government's own expert said that this terminology was ambiguous. The government's own expert said that...
Not this phrase. He never said this phrase was ambiguous. Like, I didn't see anybody argue that high risk of morbidity was itself ambiguous.
But at the time that the patient presents for the encounter, there is a potential risk of morbidity because of what was going on at the time. That's what Mr. Misko said.
Well, there'd always be some theoretical, metaphysical concept that there'd be a risk of morbidity, but focusing on the 5 particular individuals here, what evidence is there in the record that they were subject to some high morbidity risk?
The evidence, again, Your Honor, is that they're there because of they were afraid that they might have been exposed, and even if they didn't say that they might be exposed, 3 of them, I think, said that they had symptoms, or 2 of the 5. I forget if it was 2 of the 5 or 3 of the 5. But again, the regulations and the guidance were clear that you were to presume exposure to COVID. And at the time, The risk was high. You did not know what was going to happen.
So counsel, to be clear, are you disagreeing with your colleague's statement that expert testimony was not required of the government? Are you saying that in this particular circumstance that they needed to present medical testimony?
Yes, sir, Your Honor, that's exactly what I'm saying, and that's what Judge Bordar found in his 90-page opinion, and he made that very clear, that there are instances where you have a complicated regulatory scheme like this with terms that are not easily understood. When the government's own expert acknowledges that they're not easily understood, that expert testimony is required to explain those terms, because otherwise you're left with, and what the government did at trial and what they did in their briefs and what they do here today is they revert to Dr. Elfenbein's subjective intent and things that he said and did. And that is a conflating of the two elements that's just not allowed.
Do we have any instance in which, you know, a regulation tells us to apply the common language usage meaning of words like high risk of morbidity, and to suggest that that common language usage can only be understood through an expert? And if it's going to be an expert, it shouldn't be a doctor, it should be a linguist, right? You should get somebody who's a linguist to understand what the common language usage is.
Well, Your Honor, I am certainly not aware of any regulation in the CPT manual that says that, that's for sure.
I'm reading from it.
What?
That's JA 100. Apply the common language usage meaning to terms such as
no, I'm
high,
sorry, I
medium,
misunderstood
low.
the question.
I'm literally reading the
No,
language.
Your Honor, I misunderstood the question. But that's the point that I was making earlier. And the government's own expert, along with Mr. Misko, said that you can't just rely simply on that common usage. You can't just rely on what's in the manual. You've got to look at the guidance. You've got to look at the other regulations that come out. That's how you define these terms. And I just think it is grossly unfair in a case like this with complicated terminology, with these different levels, to say that the jury should just use its common sense.
But I'm sorry to interrupt, but to go back to the very beginning of the argument, I'm unclear on why the jury couldn't consider the falsity of information about the 5 individuals receiving particular exams that didn't happen.
Okay.
And of course, the defense could argue, well, that was an accident. It was a template. They made a mistake. But the jury was able to consider the fact that they said, oh, they took your temperature. I never had my temperature taken. I talked to a doctor. I never talked to a doctor. Why is that not a legitimate area for the jury to decide that it was false as opposed to some other explanation?
Yes, Your Honor, I understand your question. And it would be relevant if history and exam were criteria or factors that were utilized in determining what was the appropriate level. But in 2021, CMS issued an interim final rule which specifically said that in making the determination which level, history and examination do not apply.
Well, I understand that, but why couldn't a juror conclude that it made it more likely that this was part of a scheme to claim a higher level than was medically appropriate, and the evidence of that in part was a willingness to make up things on the documents?
Because it's not the regulation, if I can add on to Judge Nachmanoff's question. It's not that the regulation made a change in definition. It's that tests and other things that were said to have happened didn't happen, and I don't see how the regulation makes a difference there.
Well, there is, importantly, no evidence in this record, none, that Dr. Elfenbein instructed any one of his providers to put down false information in the medical records.
That's a
None.
different way of just saying it was an accident. Your argument is that that was accidental.
Well, I am, because Judge, what you're suggesting to me is, couldn't the jury decide, based on that? And what I'm saying is that's not the case that the government presented. And in fact, there's multiple instances where the government said on the record, we are not arguing that the patient was not seen by a provider. That's a direct quote from the government. That wasn't their case. their case was about whether or not level 4 was the appropriate claim for this encounter. And to determine whether level 4 was the appropriate level for this encounter, the government had to prove that that was false. And the falsity is based on whether or not it was not an undiagnosed new problem with an uncertain prognosis, because all the other factors are agreed upon. And who defines what undiagnosed new problem with uncertain prognosis is? Only Mr. Misko.
No, well, the CPT code does, right? We read it earlier, right? It's likely to result in a high risk of morbidity.
Right.
Right? I mean, that's the definition. That definition comes out actually from both experts, I believe. They read that part. It's introduced into evidence. Can I ask a question with judge's permission?
Your Honor, I'll stand up here all morning with
Yeah,
you.
no, I wasn't asking for your permission, I assure you. So your client testified at 2239. I know you don't have it in front of you.
No, I
but
don't, Your Honor, I'm
just
sorry.
accept my representation here. I'll read it to you. Where he says, what about the third column, morbidity or mortality? Did you look at that? I did. I didn't see anything that fit what we were doing for the vast majority of our COVID patients, so you know it was very low, minimal or low risk. I asked this question in a different way earlier, but I'll ask it to you now because it might matter, to me at least. That seems to be testimony from your client that the risk of morbidity at the time of presentation was low or minimal. And if that is true, then it cannot be, in my mind, an undiagnosed problem with uncertain prognosis, because there's not a high risk of morbidity. We just said, your client said it was a low risk of morbidity. Do you want to have a crack at explaining why that evidence alone from your client is not sufficient to say that a jury could have concluded that the risk of morbidity from COVID, you know, whatever it is, less than 1%, right? They're sort of like intelligent people, that your client agrees that there's a low risk when it presented to them?
Right. So I would say two things, Your Honor.
Great.
Number one, respectfully, I think this is conflating again what the government did with subjective intent with falsity of the statement. Because Dr. Elfenbein could have been wrong. He could have been wrong. There are many, you know, if the defendant, in another, use a hypothetical, if the defendant thinks that
Well, when you say he could have been wrong about what?
whether or not it's low or high morbidity.
Okay.
Yep.
I'm sorry, Judge, whether it's low or high morbidity. And he could have been wrong. You have to focus on, we're focusing on the falsity prong, and whether or not the statement is false, you have to look at that. So,
Okay, so whether
that's number
he could have
one.
been wrong, and so I understand that argument. So your argument there is the jury should have disregarded his testimony as a doctor that there's a low risk when you're presenting with COVID. I understand that argument, but let's assume it's not a helpful one for you. How about go to the second argument?
Well, to turn it back, Your Honor, I think you're setting up the construct a little wrong. It's not a question of the jury accepting or not accepting what Dr. Elfenbein thought. It's a question of whether the government has presented competent evidence to prove that.
Not on the Rule 29 inquiry, right? So we have to take every inference in favor of the government.
No,
Your
but
Rule 33 argument might be better, but on Rule 29, it actually sort of flips that around a little bit,
No,
and I've got to see, is there any inference that can be drawn?
Well-
And perhaps, let's just imagine, like a medical doctor testifying, any medical doctor testifying that they present with a low risk of morbidity, like, is some evidence that, like, folks showing up for testing presented a low risk of morbidity.
Right. So, but again, Your Honor, what I would say, even at this stage is, if there's not competent
Even if
evidence.
I'm sorry, I just didn't hear what you said. Even if what now?
What I was saying, Your Honor, was that, I forget where I was beginning, but the point I was trying to make.
All right.
Let me try to make my point. The point, I think what I was saying is I was respectfully pushing back a little on Judge Richardson about the current standard. And what I was going to say is that if they don't present competent evidence by which a reasonable jury could find that the level 4 was reached, then the Rule 29 is appropriate. That's what Judge Berdar found.
So let's just, I want to hear your second point, but let me just follow up with this, if you don't mind, Judge. If the government had put on a doctor, expert, they didn't, I understand this, but hypothetically, if they had put on a doctor, expert, who said, I find that the risk of morbidity from a patient showing up, a healthy patient showing up with COVID exposure is minimal or low. Do you agree that had they put that evidence on, that would be sufficient for a jury to find that this is not an undiagnosed problem with an uncertain prognosis?
Well,
Might not mandate that they find it, but it would be sufficient evidence, right?
you're not going to let me cross-examine that expert?
Well, yeah, not reviewing Rule 29, but
No, what I...
you get my point, right?
I do, Judge.
That would be some evidence.
And I'm being a little flippant, I
Yeah.
apologize.
No, that's fine.
Yeah,
I don't
no,
mind it.
Okay, I can tell. That would be, yes, that would be some evidence.
Some
But-
evidence,
But,
okay.
but the point again, Your Honor, is that it's not how the manual is set up. If you meet the other two elements, then, you've reached the level 4.
Right.
And finally, the last,
Yeah, I'm
Judge
close.
Agee, if I can just respond to
The
Judge
second
Richards'
point,
first.
yeah.
Yeah, one sentence, because I'm going to come back to what I've been saying, I think, consistently, is you do have to look at Mr. Misko's testimony. He addresses this issue and talks about why he believes that the uncertain prognosis was there because of this state of play, so to speak, at the time, and I think that's enough. There's certainly no other evidence that shows it, and the government didn't present any.
Well, before you sit down, I'd like for you to take about 2 minutes and give us your response to the government's Rule 33 argument.
Well, judges, as you noted, the standard, of course, is very different, and Judge Berdar, found that there simply was not enough evidence to support. He looked at the testimony of each of the witnesses and found that was not sufficient. And with the different, making his own assessment, if you will, of the evidence, he found that that was not enough. And so that would warrant the new trial.
All right. Thank you very much. Mr. Mettinger, you've got a little rebuttal time.
So thank you, Your Honor. I'd like to go back to a point that you raised with my colleague about, common sense in juries, and that really is the crux of our argument, Your Honor, that juries can use their common sense. We trust juries to make this decision. In other words, they have to find the criminal element of whether it was false or not. They did. There's certainly enough here in the record, in our view, crediting all the inferences. And so, we think that should drive the analysis. I want to mention Sarwari. That was this court's decision, and it talks about who are we going to trust to decide arguably ambiguous terms. This court said very clearly we're going to trust juries to do it. There's a really long footnote where the district judge basically tosses Sarwari aside. I think that's an extra ground for error. I think we have to follow this court's precedents, which say juries find the elements. The second thing I want to respond to that my friend said, he did say, just as Judge Berdar did, that in this case, expert testimony is required. Again, we disagree with that for the reasons we've stated under Sanjar. Also, I just think it's extra constitutional, it's extra legislative. In other words, Congress passed a healthcare fraud statute. They didn't say that it had to be proven by expert testimony. I think that is just sort of adding an element or a thing that the government has to do that just is not there in the statute.
But you were going to try to prove it by expert testimony.
Sir, we can prove it if we wish, but we
Right.
don't have to. And again, their argument and Judge Berdar's opinion, JA 6015, 6017, he's saying over and over again, essentially, expert testimony is required, and that's wrong as a matter of law in criminal law. Judge Richardson, getting to the questions that you had about this high risk of morbidity, I actually had in my notes the very quote that you had on JA 2239, where Dr. Elfenbein says there's a low risk. So I think based on that admission alone, they can't get to these level 4s. But I'll also point out JA 4487. That's an email from Dr. Elfenbein, and he basically says that, look, if these patients look bad, if there is something that is actually wrong with them where they require care, we're not taking care of them. You send them to the ER. I think the jury can reasonably say, if that is the construct here, this is not somebody with a high risk of morbidity. If they have a high risk of morbidity, they're not being seen by this clinic. They're being sent down the road. And so I think the jury could reasonably say, there was no risk of high morbidity here. They were dealing with asymptomatic patients. That's the thing we have to remember. These people sitting in their cars were asymptomatic. And so they weren't showing any signs of morbidity.
But you
or
could face a
distress.
high risk of morbidity and be effectively asymptomatic, right? That's the very example of the lump in the breast, right? Like that doesn't help us answer the question, right? The fundamental question comes back is like, for these 5 people, given their health profiles, ages, diabetes, and the like, did they face a high risk of morbidity, right? It seems like to me, be a question of whether they're symptomatic today or not. And if they look really bad, send them to ER, right? That's a reflection of how acute it is at the moment. The question we've got is, what is their risk of morbidity? And that question can't be answered by simply asking how they feel today.
Right, I get your point. The only small quibble I'll have, Your Honor, is I do think a lump in the breast is a symptom. In other words, you feel it there, that's a thing. These patients had nothing. And so that's a small quibble, but I take your point. Your Honor, I also want to just mention for the record again that, we have this very elaborate defense about the CPT manual. It came out on cross that Dr. Elfenbein didn't even consult it before coming up with this whole scheme. So this was all post hoc. This was all after the fact. So, Your Honor, I think the jury reasonably gave 0 credibility to that. It was a post hoc created defense. So at the end, Your Honor, I'll just conclude by saying, the jury did the hard work here. They weighed the credibility. Certainly, we believe that their judgment deserves deference, and so we ask that you reverse. Thank you.
We thank both counsel for their excellent arguments. We're going to come down and greet you, and then we'll move on to our last case. Be seated. Our next case is United States versus Stover. Mr. Kingsbury.
Good morning, and may it please the court. My name is Doug Kingsbury. I appear this morning on behalf of the appellants Gigi and Arthur Stover. This is an appeal of the entry of summary judgment on the issue of whether the government's claim was barred by the 10-year statute of limitations. The factual issue revolved around the government's assertion that in December of 2008, the Stovers submitted a proposed installment agreement to the IRS, which operated to toll the statute of limitations. The Stovers, on the other hand, contend that that didn't happen until 2009. So that was the factual issue. What I want to do this morning is list for the court.
The parties, I think, are in agreement that if indeed it didn't occur until 2009, then the IRS is out of time.
The parties agree. That's why the dispute is material. What I'd like to do this morning is list for the court 4 reasons why there's a genuine issue of material fact here, and in fact, why a reasonable jury could return a verdict for the Stovers on this issue. And I want to begin by framing the factual issue this way. The government's case rests almost entirely on the entry in a IRS transcript which reads pending installment agreement, and there's a date of December the 12th, 2008. The Stovers contend that that entry had to have been made in error because they didn't contact the IRS about a proposed installment agreement until 2009. The first reason why there's a genuine issue here revolves around the
Is
fact.
your argument limited to it being an error? I take that to be one of the arguments. I thought I understood you to also be making the argument that it might represent something else. It might have represented something short of a formal request for an installment agreement. Are you making both of those arguments, or is it just, right? 'Cause you
Yes.
could read this as saying a number of different things. One is like, this was just an error, right? So it's like they shouldn't have entered anything at all. But you seem to also make a second argument that maybe it's not an error, maybe it just reflects sort of their supposition that an installment agreement would be requested because an installment agreement request requires specific information to be included?
Yes, the primary argument here is that it's a mistake entirely because the Stovers' testimony is that they didn't contact the IRS at all about this until 2009. But, I mean, there are several possibilities of why this could have been done in error. One is, as we pointed out in the brief, in one place, the revenue officer conceded that she got this case mixed up with another of her cases. She had 37 cases, and she said, I really need to get this down to 20. And I thought the Stovers had submitted an information collection statement. And you know what, I got it mixed up with one of my other cases. They really never did submit one. So that's one possibility of how this could have been done in error. Somebody opened the transcript and got it confused with a different taxpayer.
But so long as there are possibilities that it could be something other than an error, that's all you would need at this stage, isn't it?
That is absolutely correct, Your Honor. But if I will go ahead and summarize these three additional reasons why there's a genuine issue here.
As you go through that, as I understand the IRS's argument related to this Form 4340 that has the entry on it about a request for installment agreement pending, part of their argument is that because it is on this IRS form that it should be presumed to be correct, and the presumption is such that it would foreclose a finding of a material dispute of fact, and therefore they would be entitled to summary judgment. What's your response to that argument?
On the presumption of correctness, yes. So, and that argument resounded with the district court. There are three reasons why the presumption of correctness does not apply at this stage of the proceeding. The first is, as we pointed out in this court's decision in O'Connor, we can't use the presumption of correctness to supplant the traditional Rule 56 standard. You know, the presumption says we're going to infer in favor of the movement that this is correct, and you have to overcome it at summary judgment. But as this court said in O'Connor, you can't use that at the summary judgment stage when you have to, all inferences go against the movement. And we're going to accept the facts as put forward by the non-movement as true at this stage, even though this court said at trial we may have a presumption applying a presumption of correctness that the non-movement will have to overcome. That's the first reason.
So in that case, if this was at the trial stage, if the trier of fact did not find the Stover's evidence convincing, it could apply a presumption of correctness to establish the date?
I'm going to, if we get to the trial stage, I would say no to the trial court judge. We don't apply the presumption of correctness in this case for two reasons. One is, I don't believe this is the type of factual assertion by the IRS to which the presumption of correctness applies. Normally they apply when there's been some analysis, some determination by the commissioner. Here what we have is basically a naked statement on a transcript with, and I'm going to address this in a moment, no foundation for the basis for this entry. And as the United States Supreme Court held, and I apologize to my colleague because this is not in my brief, United States versus Janus 428 United States 423, a naked assertion by the IRS without foundation is not entitled to the presumption of correctness. And the third reason that I would push back at trial that it doesn't apply here is because after this court's decision in O'Connor, Congress amended the statute that governs burden of proof in these tax cases, 26 United States Code Section 7491, which now reads, and this is allocating the burden of proof, if, I'm quoting now, if in any court proceeding a taxpayer introduces credible evidence with respect to any factual issue relevant to ascertaining the liability of the taxpayer, the secretary shall have the burden of proof with respect to such issue.
Counsel, I'm sorry to interrupt. Can I just stop you there, though? Just, can you articulate what the credible evidence is in the record that the taxpayers introduced? I understand the criticism with what the government's transcript says, but what is the credible evidence?
Well, first, let me go right to the deposition testimony of Mr. Stover. Joint Appendix, page 161, he explains how the money that they had planned to use to pay their taxes was invested in the stock market. The stock market crashed in 2008, and they didn't have the available money to pay the taxes. He said at Joint Appendix, page 170, but at Christmas time, so this would have been after the alleged request for an installment agreement, at Christmas time, he testified, we still thought we were going to be able to be okay. We thought the market was going to turn. Page 168.
Let me stop you there, and I think we've all looked carefully at this. What this isn't is an unambiguous affidavit or declaration from the taxpayer saying, in the month of December of 2008, we never contacted the IRS, we never requested an installment agreement. There's a lot of sort of somewhat confused language about, I don't remember having done this, or I contacted a CPA, I think these things may have happened in 2009. In a certain ironic twist, when asked how he remembers this, he says, well, I looked at the transcript. So to a certain extent, he's saying the transcript is reliable for me trying to reconstruct what happened, but with regard to this entry, it's not accurate, but I can't tell you exactly what happened and when. So is there any significance to the lack of clarity in the deposition, or is that the best evidence that there's a rebuttal for a fact finder to decide with regard to whether the statute of limitations was told as a result of actions taken by the taxpayer in December of 2008?
Yes, Your Honor. First of all, let me say the taxpayers did file affidavits in this case, specifically denying that they ever contacted the IRS in December of 2008.
Is that in the record?
That, I'm just about to explain. They are in the record. They are at docket entries 35-2 and 35-3. They are not in the joint appendix, and that is entirely my fault. I missed it. I was not trial counsel, but they were in front of the district court. And what happened? The reason I missed it was because
these affidavits were submitted to the district.
Yes, yes, Your Honor, they were submitted.
I'm not recalling that Judge Conrad addressed those, and he did not address the deposition either. I know you were trial counsel, but what did trial counsel do to alert the district court that this evidence was there?
The affidavits? Or
the affidavits or the deposition?
I don't know the answer to that, Your Honor. But I do know that the district court addresses the factual contentions by the Stovers that they were denying that they had contacted the IRS in December of 2008. But he wanted them to produce some additional evidence to corroborate that denial. That's how I read the order. And I do want to say briefly in defense of my colleagues here for the government, she also was not trial counsel, and she would not have known, just like I didn't, that these affidavits had been filed, so they were not misleading the court about that. But they are in the record, as I said, at docket entry 35, 2 and 35, 3. But if I could just continue briefly, I do think it is a little more specific in his deposition testimony. He does say clearly on page 168, it wasn't until 2009 that we realized that we weren't going to be able to pay it. We contacted our CPA to set up an appointment. The first meeting was in February because we couldn't get on his slate until February. And then he says, quote, before I met with the CPA in 2009, I don't know that I even knew that there was a pay period or pay schedule that was possible. Now, if the jury accepts that testimony, it seems highly unlikely that he would have submitted a proposal for a pay schedule 2 months earlier to the IRS.
But in some of the cases that both sides have cited, there's in fact affirmative evidence that the transcript, whether there's a presumption of regularity or not, might be wrong. Not just a hypothetical possibility, but for example, in this case, I would have thought there would be a letter from the CPA to the IRS saying, here's our proposal for an installment agreement. We'll pay $500 a month, dated June 1st, and that would be clear that that was the first communication. Or, on the contrary, if it said, please ignore the prior requests from the taxpayer made in December of 2008, they can't do that, I'm involved now, it should be X. But here we just have a total absence of anything contrary to the transcript in December of 2008, right? That would corroborate what you've suggested, which is that for the first time we talked to the CPA in February, for the first time in the summer, there was back and forth with the IRS.
Well, what corroborates Mr. Stover's testimony is that, in fact, the records show in February of 2009, the CPA presents the power of attorney form, and then shortly thereafter submits a request for an installment agreement and supporting documentation from 2009 in support. On the other part of the ledger, there is no evidence of any communication, other than the transcript, that the taxpayers actually made this request in December of 2008. There's no witnesses with personal knowledge. There are no documents either evidencing the contact or the proposal. And there's no internal IRS record of a contact from the Stovers in December of 2008. And we know from the joint appendix that every time, may I finish this answer, Your Honor?
Yeah, please, go ahead.
Every time that there is a contact between the taxpayer or his representative and the IRS makes an internal note of that contact. Who made the contact? What was the subject? What was discussed? And what's the plan of action? And we see that throughout the archive history in this case. There is no record of any contact with the Stovers in December of 2008. And there's an inference to be drawn from that, I argue, at the summary judgment stage. And it would be an inference to be drawn by the jury as well, that the reason there's no records is because there was no contact from the Stovers in December of 2008.
Can I ask one question before you go?
Yes, Your Honor.
Sorry. So docket entry 35 that includes the two affidavits that you're describing was withdrawn 2 months later in docket entry 39 by your clients, which means it wasn't in front of the, like once it's withdrawn, it's not in front of the district court. So help me understand how the district court was supposed to like comb through and find two affidavits that were allegedly attached to a withdrawn motion?
What I know is reading the order itself, and twice in two different places in the order the judge refers to the motion to which the affidavits were attached, and that some of the arguments were incorporated into the response in opposition to the motion for summary. That's the reason that I say that we know that the judge knew about it. And my mistake is I can't tell Your Honor why they got filed, because the motion and the response were filed back to back, and why the affidavits got filed. I don't know if it's part of the CMSE filing system. I don't know why they got filed with the motion instead of with the response document. I don't know the answer to that, but I do know, because the judge refers to it twice in his order, that it's reasonable to assume that the judge was aware.
Thanks.
All right, thank you very much. You've got some rebuttal time.
Thank you, Your Honor.
Ms. Avetta?
Thank you, Your Honors, and may it please the Court. Julia Vetta for the United States. I would like to speak very briefly first to the point raised about the documents filed at docket entry number 35. As Judge Richardson observed, that was a motion for sanctions filed by the taxpayers who were dismayed that the IRS had abided by standard document retention policies and failed to retain documents that they had provided in support of their proposal to enter into an installment agreement. In support of this motion, they produced affidavits, which were the only point in the record at which they actually attempted to create any dispute of fact as to when that proposal was made to the IRS. They withdrew the motion for sanctions.
So you're excluding the deposition when you say that?
The deposition was taken by the IRS. It was an attempt, I believe, to elicit from the taxpayer a clear story of how this came to be, because, as is clear, the IRS records for the period of time before the debt was transferred out of the automated collection system and to a human revenue officer is thin. There is not fulsome documentation of contacts with the taxpayer because it wasn't assigned to a person, to a revenue officer who was managing that account, dealing with the power of attorney, dealing with the taxpayer, and attempting to negotiate the agreement. That did happen.
All right, okay. Help me understand in the context of looking at the deposition, which was part of the record. If it creates a material dispute of fact, isn't that all that it has to do?
If there were deposition testimony that clearly said, I did not contact the IRS.
Well, I think everybody can agree that this could have been clearer. They probably should have had an affidavit, but if you
I think that's a material distinction there, Your Honor.
Right, okay. Well, if you read the deposition to support what the taxpayer argues here, and there are several places in the deposition where it seems to me, at least to me, pretty clear that he's saying, you know, we didn't have contact in 2008. We had contact in 2009. And if that were found credible by the trier of fact, that would be sufficient upon which to return a verdict for the taxpayer. So why wouldn't we have a dispute of fact here? I mean, the Stovers say it didn't happen in 2008. And the IRS has a document that says it did happen in 2008. So they have a fact claim that says this. The other party has a fact claim that says, no, that's not right. Isn't that just a classic summary judgment situation where you can't render a decision on a material dispute of fact?
If the situation were as Your Honor described, and there was sworn testimony that I did not do this, which is not what we have on this deposition. That's a very generous reading of this deposition. But had there been an affidavit, had there been unambiguous deposition testimony, had there been a clear statement that this transcript is erroneous and it represents something that did not happen,
Right.
that would be the dispute you're describing.
If you had that, this would be an easier case and an easier decision. But it seems like, and maybe I'm interpreting your argument wrongly, that you're saying that the deposition is not credible as a matter of law for summary judgment purposes.
We note that the taxpayer contradicts himself twice in the space of 10 pages.
Wait a minute. Are you saying that the deposition is or is not credible as a matter of law?
I don't think that the court at the summary judgment phase takes a position on credibility as a question of law. I don't think it can. I think that if there's a credibility question, I think that alone could defeat summary judgment if there was some wrinkle that would be outcome determinative with regard to credibility. Here, there is not a credibility question raised. The questions raised here have to do with the taxpayer's recollection. He is saying one thing and then saying, oh, no, wait, and changing his story, and doing that again and again and again. Now, if he wanted to make a clear statement, he had the opportunity to do so, and I'm going to go to the next part of Your Honor's question.
Why do we
Sorry.
think, I mean, why, you keep saying he doesn't have clarity and it's not unambiguous, but typically in a summary judgment context, we sort of draw all reasonable inferences in favor of the non-moving party, right? Like, totally get you at trial, right? Like if he said all this, like you'd stand up to the jury and be like, you can't believe that gibberish, right? I totally get it. But we have to draw all, like, instead of clarity and unambiguousness, at summary judgment, we typically say the opposite of that, which is we draw all reasonable inferences, right? Even if you don't say it exactly, like we're giving you the benefit of the doubt. How do you, like, command clarity and unambiguousness? That's not really a word. And in light of the sort of typical Rule 56 standard we apply?
Well, that's where you get to the presumptions underlying the IRS records.
All right, and do you agree? So I won't have you talk about those. But would you agree that if the presumptions did not apply, were I to find that presumptions did not apply, and this was just a standard summary judgment case, that in that situation, taking all reasonable inferences in favor of the taxpayers here, that there's a dispute of fact?
I still think that more would be required.
And why?
Because,
that's what I'm not understanding.
Because
and I understand the presumption piece, and we can talk about that. But all reasonable inferences, you think we cannot read the deposition in a manner to say that he did not call in 2008?
It is not self-controverting evidence. The debtor, the taxpayer must produce controverting evidence. If there is a dispute as to fact, he can't just say, I said what I said.
Wait a minute. Why isn't his testimony, look, we didn't meet with the CPA till 2009. This is the first time we had any contact. Why isn't that sufficient? I mean, it may very well not prevail at trial, but I'm just not understanding why you're saying that is not a fact that contradicts what the government presents.
Because, Your Honor, the record does not indicate that the CPA initiated the contact in December of 2008 that led to that entry.
The weight of the evidence before the trier of fact, because now you're asking us to make evidentiary conclusions at the summary judgment stage based on lack of what could have been in the record.
We are asking for no negative inferences, Your Honor. We have a position that a record that a call center was contacted, and this can be done by individual taxpayers. And it can be done by individual taxpayers who aren't even necessarily attempting to propose an installment agreement. You can call the automated collection system and say, it looks like I'm facing some financial difficulty. What are my options? How can I pay this debt? Can I offer to compromise it? Might I be able to pay it in installments? There are all sorts of conversations that can be had with this call center individual that won't make it onto the record. And when it did finally get to a human revenue officer, they note, I don't have anything from ACS. There is no archive history here of what happened in this point of contact. But there was no question at the time that the revenue officer received this file that there was a pending installment agreement that they were negotiating the terms of. And the question is only when was the first phone call?
When one of the judges is talking, you don't. So is what you're saying based on what appeared on this IRS form? That's the basis by which this revenue officer later made a determination?
No, Your Honor.
All right.
The revenue officer received a package of information from the Stover agency, and the contents of that is noted in her notes. And she notes also, in accordance with that, that there is a pending installment agreement code entered from the call center in the file that she received, but that is all the information that conveyed from the call center.
All right, so how does that help you out? I mean, everybody can acknowledge what's on the IRS form. I don't see how that makes your case any better.
If I understand Your Honor's question correctly, you're saying what more information does the IRS have other than a call center data entry and the fact that when a person received the file was in process and information had been received as pursuant to the kind of requests that are made in the early stages of this process. That is the evidence we have, and that is where we do get to these presumptions. The presumptions here to the certificate of assessment.
Can you explain the last sentence, I think, of your answer there? That the file included the kinds of things that were in the process. I know I'm butchering the words you used, but I guess I'm trying to figure out, I think as Judge Agee was asking, I understand the 3-word entry on the form, and I understand that an officer later looked at those 3 words and said, well, that must mean that there's a pending installment agreement. You seem to be suggesting there's something more than that, and what I want to know is sort of like more specifically, what exactly is it that I'm supposed to be looking at to understand that?
Yes, Your Honor. At page JA98, the revenue officer makes a notation that taxpayers have submitted documents verifying expenses and income, and that she's reviewing a file that includes a package submitted by their representative that includes verification of expenses.
And when is that entry being made?
That entry was made in July of 2009.
Right, and we all know, through lots of different ways, that in July of 2009, that information was submitted. Right? That doesn't change whether the request was made earlier in 2009 or whether it was made in 2008. Because we know that information, which included information for the first quarter of 2009, could not have been submitted in 2008. That information, by definition, cannot corroborate the existence of an installment plan request in December of 2008. I don't understand. That's what I don't understand. I totally get by July of 2009, there is information for an installment plan. I totally grant you that there's really good evidence of that. But why does that support in any way that the request was made in December of 2008 as opposed to January of 2009 or March or May?
It doesn't speak to the point of origin of the offer at all. And that's an important thing to consider here. If there were evidence that the offer had been made in January or February of 2009, then the information in possession of the IRS in July could be the same. This doesn't actually speak to that. You need to, what you're seeing this evidence here, the value it serves here is that this is not a case like Bode or Fry or a case where there was never an installment agreement contemplated by the taxpayers and the code was actually entered in error. What this does is corroborate basically we go back to the presumptions. This is the presumption that the IRS does not enter.
It corroborates that the IRS agent believed what was in the record, in the IRS record.
There are 2 points in response to that. The revenue officer who was working the case, the human who received the file in 2009, noted that there was a call center entry that there was a pending installment agreement. And here are some documents that supported that. That they did not.
So when we look at the package, an 8821, that's a form for representation, right?
Mm-hmm.
And so that suggests that the package here included information from not the taxpayer themselves, but information from a representative of some sort.
I believe it was their accountant, yes.
Right. Why doesn't that actually cut against you? Because the taxpayer's deposition suggests, if anything more clearly, that they didn't hire somebody to represent them until 2009. And so if we take those 2 things together, that actually corroborates the taxpayer rather than your unknown 3-word entry that we can't quite figure out?
The taxpayer's testimony actually does not support that they were not dealing with their accountant in 2008, nor that they waited until 2009. On page 163, They speak about how when they filed the return, they looked at it. It would have been in 2008. Were you aware of the tax liability when you filed the tax return in late 2008? No? Well, yes. Did Ed Lloyd, that is the person who is then reflected in these documents later on, or somebody at his office talk to you about it? I'm sure, yes. And you had to sign the return, didn't you? Yes. So you knew, and you would have signed it in 2008, probably the end of 2008, yes. There is plenty of evidence here to muddy the question of when the taxpayer and the accountant developed their position.
Well, counsel, the problem is as soon as you start to say you're muddying the question, it sounds like that's the kind of thing that makes it difficult to resolve on summary judgment. If I understand from the record in your argument, the position that the IRS is taking, it's that the taxpayers undisputably know that they owe taxes. In fact, they don't even dispute that it's $160,000, and they know that they owe those taxes in 2008, November of 2008, and that by December of 2008, they also know they're unable to pay that tax liability, and the IRS believes that they reached out through some automated line and said, we know we owe taxes, we can't pay them, we want to work this out, and then they contacted their accountants and in 2009 started to deal with human beings at the IRS to try and work it out, and therefore the statute of limitations should be told from 2008. And of course, had the IRS not waited all the way until the very 11th hour to file this, this would not be an issue. They could have filed this in 2016, 2017, whenever it was. But how is the issue clear enough on summary judgment that the date of December is when the taxpayer made the request to hold in abeyance the collection of the taxes?
Because the taxpayer has not presented evidence sufficient to rebut the presumption of correctness of the date entered on the IRS Certificate of Assessments and Payments.
So if there is a presumption, and instead in this case there had either been verified affidavits or the taxpayer was sworn and testified at the hearing, how does that affect the presumption of correctness?
Well, it is a rebuttable presumption. And if the taxpayer is able to rebut it, that defeats summary judgment. If they say, here's an actual, unambiguous, factual position I am taking, that I did not call the IRS. I did not have any contact with the IRS except through my accountant, whom I did not authorize to contact the IRS on my behalf until February 2009. That could be sufficient to defeat summary judgment.
Because we wouldn't have to draw reasonable inferences. We could just read it without reasonable inferences.
Well, you're drawing a reasonable inference that it's true. But yes, if you're saying that the taxpayer's sworn testimony is correct.
But the whole point of Rule 56 is that, like, we do draw those reasonable inferences.
Yes.
Can I ask about the presumption of correctness? I had a case last year in the IRS. Your colleague stood there and said the exact opposite of what you're saying, said there was a date in the record as to when something was submitted. It's literally the same basic context. There's a case called Pond. And the IRS lawyer said, that must be wrong. So it's wrong. That data entry is wrong, and you, court, should ignore it. And we rejected that argument. But it seems odd to me to be in a world where the IRS is representing in some cases that we should ignore the dates that are included on their documents, and in other cases we should absolutely defer to them absent perfect crystal clarity from the taxpayer on the other side, which ought to be really hard because we waited a darn decade to show up and challenge what had happened. This seems like a problem to have an IRS that's running a railroad that way. Do you have thoughts about why the IRS in one case says ignore our dates and in another case is telling us that we must abide by them?
In cases where the presumption has been rebutted, we will not stand by evidence that is demonstrated to be incorrect. I cannot speak to the context of that case. I'm not familiar with that record. I can only assume if a colleague of mine took that position here that that must have been that in the record there was something that rebutted that presumption, that made clear that there was an erroneous transcript entry. That is not present here. Here, all we have is an entry that is presumed correct, no affirmative evidence in contravention of that position, ambiguous evidence that can be charitably read, potentially to raise an issue of fact, but no affirmative evidence contravening that presumed correct data entry, and a volume of subsequent evidence indicating that, yes, there was an installment agreement proposed, there were terms negotiated, and this went on over time, and at no point was anyone protesting and saying, IRS, you're wrong. IRS, this isn't what I said. This isn't what I want. This isn't what I'm trying to make happen here. It was, the question is, when did the process start? And all of the evidence is that the process took its ordinary course without objection from either party. So the evidence that it started when the IRS said it did is unambiguous, and the evidence that it didn't start when the IRS said it did is thoroughly ambiguous. So the presumption has not been rebutted on this record here, and we would stand on that. We would say that the presumption does not arise between summary judgment and trial. It arises at the point of origin of the information whose correctness is in question. And if the burden is never on the commissioner, on the IRS, to reprove its own evidence, unless, as Your Honor noted, there are patent contradictions in the record or points where the commissioner can't reasonably maintain that the evidence in that certified transcript is correct. When you know it's not, you know it's not. Here, we don't know it's not, based on the taxpayer's testimony. And that is why summary judgment was appropriate here. We come into this with a presumption in favor of the commissioner that says, you're keeping good records. You're doing your job as you're supposed to. And I on that point, want to speak to the lower court's distaste and Your Honor's expressed distaste for the apparent delay in enforcement.
Do that quickly, because you are over.
I do see that, I'm sorry. The statute of limitations is 10 years. And over the course of these 10 years, the IRS engaged in multiple cooperative and administrative attempts to collect the tax before the suit was referred to the Department of Justice. They did the math and observed a stay on levy action from December 12, 2008 through September 16, 2010. So those 643 days are added on at the end. That's not delay. That only ever adds up to the 10 years that Congress has granted the IRS to collect.
All right, thank you very much.
Thank you.
Mr. Kingsbury, you've got some rebuttal time.
Thank you, Your Honor. I'll be brief. I have 3 points to make. First, Judge Richardson, to the extent that it matters, that it's important at all to you, the 2 places in the district court order I was referring to are Joint Appendix page 347 and 353. That's where the district court refers to the motion for sanctions and the arguments contained therein.
And your position is that that incorporates affidavits that were filed at that time?
Well, I believe the judge was, the court was aware of them. That's my argument. I can't prove that, obviously. The only thing I can prove is that they were submitted to the district court. That's all. It was in response to the question, why wasn't there an affidavit? There was an affidavit. My second point is the inference to be raised by the fact that in order for this to have been a valid proposal to toll the statute of limitations, and the government agrees with this, the taxpayers would have had to have proposed a specific monthly or periodic payment in a specific amount. And the IRS records show there was there's no record of any specific amount having been proposed by the taxpayers until October of 2010. In my brief, it's wrong about that. I said it was 2009. It was October of 2010 when there was finally a proposal for a specific amount. And the inference to be drawn from the absence of any record of a specific amount prior to that, is that there wasn't a valid proposal made in December of 2008, because there's no evidence that a specific amount was proposed. And the last point I wanted to make, just to follow up on Mr. Stover's deposition testimony, which I believe needs to be read in the light most favorable to Mr. Stover, and the inferences to be drawn that are favorable to him should be applied at the summary judgment stage. He testified that in the 2009 meeting with the CPA, he said, we explained to the CPA the pickle we were in, and we asked the CPA to contact the IRS to find out what our options were. Well, if that's believed, he didn't know what his options were prior to that. And then on page 165 of the joint appendix, he says the CPA rolled out what his plan was. He was going to reach out to the IRS and find out what their options were. Specifically, and this is on 166, he was going to see if they, the IRS, would agree to a payment schedule. Now, in the light most favorable to Mr. Stover, he's explaining the chronology of how the contact with the IRS, the first contact, occurred. And I think the inference to be drawn there in the favor of the Stovers was, this is the first contact with the IRS, and all I would say is the documents we do have in the records corroborate this chronology, because it's in February when the power of attorney form is filed, and it's followed shortly by, according to the records, a cover letter from the power of attorney, a request for an installment agreement, and supporting documents. That's evidence from which a reasonable jury can conclude that we're going to credit the Stover's account of this and find that, in fact, the entry from December of 2008 was made in error. Thank you, Your Honor.
All right, thank you very much. We're going to come down and greet counsel, but first we'd ask the clerk to adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.